Question number 801. Who among the following is a competent witness under section 118 of the Indian Evidence Act? Option A, a person who is unable to understand the questions put to him due to disease. Option B, a child unable to understand questions put to him. C, a lunatic able to understand the questions put to him. And D, a person unable to understand the questions put to him due to extremely old age. Here a competent witness is option C, that is a lunatic able to understand the questions put to him. Question number 802. All persons are competent to testify unless the court considers that they are prevented from understanding the questions put to them because of tender years, extremely old age, mental disease, all of these. Here correct answer is option D, all of these. Question number 803. A person suffering from schizophrenia is not competent to testify, can testify if he cannot communicate verbally, can testify if he can understand the questions and answers them rationally, can testify through his father who understands the questions and can give rational answers on his son's behalf. Here correct answer is option C, can testify if he can understand the question and answers them rationally. Question number 804. Which one of the following is not a competent witness to testify under the Indian Evidence Act? Here correct answer is option D, idiot. Idiot is not a competent witness to testify under the Indian Evidence Act, whereas person capable of understanding the questions put to them, quote, unchaste woman, witness unable to speak are competent witness to testify. Question number 805. A witness who is unable to speak is called dumb witness. Question number 806. Who amongst the following are competent witness? Chance witness, victim of rape, related witness, all of these. Correct answer is option D, that is all of these. Question number 807. Who among the following is a competent to adduce evidence under the Indian Evidence Act? Dumb witness, deaf witness. Select the correct answer by using the codes given below. Here correct answer is option C, both 1 and 2. Question number 808. Dumb witness may give his evidence by writing or by sign in open court. Such evidence shall be deemed to be, here correct answer is option B, that is oral evidence. Question number 809. In which one of the following is not correctly matched? Child witness section 118, dumb witness section 120 is not correctly matched, whereas hostile witness section 154 and expert witness section 45 are correctly matched. Therefore, here answer will be B. Question number 810. Which of the following statement is incorrect regarding dumb witness? A dumb witness may give his evidence by writing in open court. A dumb witness may give his evidence by signs in open court. Evidence given by a dumb witness in writing before the court shall be deemed to be a documentary evidence. A dumb witness may give evidence in any manner which can make it intangible. Here correct answer is option C. This is incorrect. Evidence given by a dumb witness in writing before the court shall be deemed to be a documentary evidence is incorrect. It will deem to be an oral evidence. Question number 811. Which section of the Evidence Act removes the bar doctrine that husband and wife were one person in law? Here correct answer is option C, section 120. Question number 812. What is the evidentiary value of evidence given by husband against wife and vice versa under the Indian Evidence Act? Here correct answer is option D. Evidence can be adduced by both in civil and criminal proceedings. Question number 813. A document containing a communication from a husband to his wife in the hands of a third person is. Options are not admissible in evidence until consented to by the writer of the communication. B, not admissible at all. C, admissible in evidence. D, none of the above. Here correct answer is C, admissible in evidence. Question number 814. Husband and wife are competent witness against each other in civil and criminal cases, only in civil cases, only in criminal cases, only under investigation. Correct answer here is option A, that is in civil and criminal cases. Question number 815. Husband or wife are permitted to disclose any communication between them during marriage. In civil proceedings between the parties, in criminal proceedings between the parties, in matrimonial proceedings between the parties. Here option D is the correct answer, that is all of the above. Question number 816. Which of the following is true and correct? Option A. In all civil proceedings, the parties to the suit and the husband or wife for any party to the suit shall be a competent witness. Option B. In criminal proceedings against any person, the husband or wife of such person respectively shall be a competent witness. C, both A and B. Here option C is the correct answer. Question number 817. As per section 120 of the Evidence Act, which of the following has been stipulated that wife of a party is not a competent witness in the civil proceedings, husband of a party is not a competent witness in civil proceedings, wife of an accused is not a competent witness in criminal proceedings, none of the above. Here correct answer is option D, that is none of the above. Question number 818. A spouse will be permitted to disclose the communication made during the marriage. Here correct answer is Option D, that is with the consent of the person who made it, in suits between the spouses, in prosecution between the spouses. Here all the answers are correct. Question number 819. A and B were married. During marriage, A committed forgery and communicated it to B, his wife. After some time, divorce took place between A and B married C. In a charge against this, forgery prosecution wants to produce A as a witness against C. Can they do? Option A, they can do as B is now married to C. Option B, they can do as forgery is an offense against public policy. They cannot do as B is bound not to be witness against A under privileged communications. D, they cannot do so as B has now nothing in common with A and is a third party. Here in question number 819, correct answer is option C. That is, they cannot do as B is bound not to be witness against A is A under privileged communication. Question number 820. In criminal proceedings against any person, the husband or wife of such person shall be competent witness, incompetent witness only if they are major with the consent of other, competent witness only if they are sane and with the consent of the others. Here correct answer is option A, that is competent witness. Question number 821. Assertion. B writes to his wife C a letter which contains defamatory matters about D. C cannot be compelled to disclose this communication. Reason. Any communication made during subsistence of marriage by a husband to his wife or vice versa is protected as privileged communication. Here correct answer is option A, that is both A and R correct, and R is the correct explanation of A. Question number 822. Which section of the Indian Evidence Act protects communication during marriage? Here correct answer is option B, that is section 122. Question number 823. Under section 122 of the Evidence Act, privilege is available to professionals, magistrate, wife and husband, judges. Here correct answer is option C, that is wife and husband. Question number 824. A communication made to the spouse during marriage under section 122 of the Evidence Act remains privileged communication after the dissolution of marriage by divorce or death, does not remain privileged after the dissolution of marriage by divorce or death, does not remain privileged after the dissolution of marriage by divorce but remains privileged even after death, remains privileged after the dissolution of marriage by divorce but not so on after death. Here correct answer is option A. A communication made to the spouse during the marriage under section 122 of the Evidence Act remains privileged communication after the dissolution of marriage by divorce or death. Question number 825. Under which section of Evidence Act a judge cannot be compelled to answer any question as to his own conduct in court as such judge? Here correct answer is option C, that is under section 121 of Indian Evidence Act. Question number 826. Section 121 of the Indian Evidence Act provides for privileges in respect of which of the following? Correct answer is option B, that is judges and magistrate. Question number 827. Privilege under section 121 of the Evidence Act is not available to an arbitrator, may or may not be available to an arbitrator, available to an arbitrator, none of the above. Here correct answer is option A, not available to an arbitrator. Question number 828. During the course of a trial of a rape case, a person present in the court causes a knife to another person before the court. The judge before whom the incident took place may not be called in evidence, may be called in evidence under the special order of High Court, may be examined as a witness. Here option C is the right answer. Question number 829. A magistrate can be compelled to answer question on his own conduct as a magistrate in court. Here correct answer is option D, by an order of court to which he is subordinate. Question number 830. The privilege to withhold the documents information under the administrative law is enacted in which of the following sections of the Evidence Act? Correct answer is option C, that is section 123 of the Evidence Act. Question number 831. Which one of the following section of the Indian Evidence Act deals with the evidence as to affairs of state? Correct answer is option A, that is section 123 of the Evidence Act. Question number 832. Which section of the Indian Evidence Act is based on the maxim solus populi est suprema lex? Correct answer is option A, that is section 123 of the Evidence Act. Question number 833. Documents in respect of which privilege has been provided under section 123 of the Indian Evidence Act as a published official record is an unpublished official record, both A and B, none of the above. Here correct answer is option B, that is an unpublished official record. Question number 834. Which of the following provision of the Indian Evidence Act deals with privileged communication about unpublished official records relating to the affairs of state? Here correct answer is option B, that is section 123. Question number 835. Under which section of the Indian Evidence Act a public servant shall not be compelled to disclose the communication made to him in official confidence? Correct answer is option B, that is section 124 of Indian Evidence Act. Question number 836. Can a police officer be compelled to disclose the source of information relating to commission of an offence? Here correct answer is option C, that is no. Police officer cannot be compelled to disclose source of information relating to commission of offence. Question number 837. For protection under section 124 of the Evidence Act, communication is to be made to a public officer in official confidence, to a public officer as an ordinary cause of his duties, to a police officer as a routine manner, either A, B or C. Here correct answer is option A, that is to a public officer in official confidence. Question number 838. No revenue officer shall be compelled to say whence he got any information as to the commission of any offence against the public revenue. This provision is contained in, here correct answer is option A, section 125 of the Evidence Act. Question number 839. Which one of the following sections of the Indian Evidence Act applies to the pleaders relating to professional communication? Correct answer here is option C, section 126 and 127. Question number 840. Communication by a client to an advocate is not permitted to be disclosed under section dash of the Indian Evidence Act. Here's correct answer is option A, that is under section 126 of the Indian Evidence Act. Question number 841. Which of the following statement is correct? Here, the protection of professional communication as provided under Indian Evidence Act in section 126 to 129 is available only for engaging an advocate to plead his case, for disclosing communication to advocate or his colleagues before communication of the offence of illegal acts, after commission of the crime or illegal acts. Here correct answer option D, after commission of the crime or illegal acts. Question number 842. Which one of the following sections of the Indian Evidence Act applies to the pleaders relating to professional communication? Here correct answer is option D, that is section 126 and 127. Question number 843. Professional communication between advocate and his client is not admissible in evidence, is a privileged communication only until the contract continues, is admissible in evidence with the consent of the client, is not admissible until it is legal. Here correct answer is option C, is admissible in evidence with the consent of the client. Question number 844. A client says to be an advocate, I have committed forgery and I wish you to defend me. His communication is protected from disclosure under section 126 of the Evidence Act. Question number 845. Deepak, accused of committing offence supplying arms, informs his lawyer Shweta that he has committed the offence and wishes her to defend him in the circumstances. Here correct answer is option C, the communication is privileged one and protected from disclosure. Question number 846. A client says to his advocate B, I have committed murder of C. I wish you to defend me. Whether advocate B may disclose the aforesaid communication in the court? Here correct answer is option C, that is no. Question number 847. Which one of the following fact is protected from disclosure in a court of law? Here correct answer is option A, a client to be an attorney, I have committed the forgery and I wish you to defend me, is protected from disclosure in court of law. Question number 848. A client says to be an attorney that he wishes to obtain possession of property by use of a forged deed on which he requests the attorney to sue. The communication is option A, protected from disclosure in view of attorney-client privilege under all circumstances. B, not protected from disclosure as attorney-client privilege does not extend to communication furtherance of a criminal purpose. Here correct answer is option B only. It is not protected from disclosure as attorney-client privilege. Question number 849. The professional communication between an advocate and his client can be disclosed before the court with the consent of the client, without the consent of the client if made in furtherance of an illegal purpose, without the consent of the client if advocate comes to know that any crime or fraud has been committed since the commitment of his employment, all of the above. Here correct answer is option D, that is all of the above. Question number 850. Legal advisor, option A, can disclose a professional communication after the death of his client, can disclose a professional communication after the relationship with the client has ended, can disclose in professional communication is made in furtherance of any illegal purpose, can disclose a professional communication of all instances. Here correct answer is option C, that is can disclose professional communication if made in furtherance of any illegal purpose.